Federal Drive is presented by GEHA, Government Employees Health Association, proudly providing health and dental benefits to federal employees and their families. Visit GEHA.com.
Last week's conclusion of the record-breaking government shutdown was great news for federal employees in general. But for a few thousand feds, it was even better news. They'd been told they were about to lose their jobs completely, and those positions are now safe. That's thanks to a provision of the legislation that undid reductions in force that happened during the shutdown. Recent court documents shed more light on exactly how many employees the Trump administration tried to fire during that time frame. Federal News Network's Jared Serbu is here with more details on what we learned from those tallies. Jared, thanks for joining me.
You bet.
This was all part of a lawsuit that unions were using to try to reverse those RIFs while the shutdown was going on. What do the documents tell us?
Well, this is sort of a compilation that we put together of various declarations that have come from agency by agency filings over the past month or so. And the grand total, it looks like, is 3,605 people that got RIF notices from various agencies since the beginning of the shutdown, October 1st. And according to the law Congress passed ending the shutdown, theoretically, stronger than theoretically, almost certainly all of those will be reversed. And that 3605 number may not be a complete tally. It is what agencies have reported to the court are covered by the litigation. And to be covered by the litigation, you needed to have been working in a program, project, or activity that was represented, or that had at least one employee that was represented by one of the union plaintiffs in this case. And by the end of the case, that was really all federal unions. So that should be a pretty solid number, that 3605. But they were consolidated in a relative handful of agencies. The biggest by far of agencies that did RIFs during the shutdown was the IRS, 1,399, followed by HHS, 982, Education, 465, and the Department of Commerce, 263. There was a very small number in the Department of Homeland Security also. Those were all within the Cybersecurity and Infrastructure Security Agency, though, just 54 in all of DHS, and that gets you to that 3605 total.
Now, this doesn't apply to any RIFs that happened prior to the shutdown, correct?
It does not explicitly, as far as the legislation that reopened the government, it doesn't apply to anything that happened prior to the shutdown. And that's actually a really important point, because one of the pieces that kept coming up during the course of this litigation was, around the question of, is it legal to fire feds because there is a shutdown or during a shutdown? You get the question of, okay, well, were some of these in process and they just happened to occur during the shutdown because that's the natural pace at which they unfolded, or were they really because of the shutdown? Congress really mooted that issue with this legislation by saying, we don't really care what the reasons were. If there was any action that any executive agency took between October 1st and the passage of the continuing resolution last week, those now have no force or effect. So the reasons now don't matter. As long as they happened prior to the shutdown, the RIFs don't count.
Well, that's a great way of clearing the tables then. What's the status of the lawsuit now that Congress has undone all those RIFs?
Well, based on everything we just talked about, we would sort of assume that most of that lawsuit is moot, or all of that lawsuit is moot, because the main issue they were fighting for has now been resolved by Congress. We don't know that with 100% certainty yet. The government has asked that the court find that the union plaintiffs' claims are moot at this point, but that has not happened. They are going to go meet, and the government is going to go meet and confer with the federal unions to see if they think that there is anything left that needs to be litigated over. But as we just talked about a second ago, the law itself does tell us some pretty specific things. Again, that the reasons for the RIFs don't matter. If it happened after October 1st, then the RIF doesn't count. And also, any employee that got that notice needs to be notified and reinstated within 5 days. Now, of course, depending on whether that's interpreted as business days versus calendar days, employees will have already gotten that, or they could get it this week, but it should be coming really at any time this month. But another thing that the law tells us is agencies really can't just turn around and reissue these RIF notices tomorrow, because the appropriations language that's in the law says that none of the funding that's appropriated by this continuing resolution can be used for those RIFs. So it's not a situation where it looks like agencies are going to be able to rescind those RIFs and then just reissue them again with a fully open government.
That's good to hear. And this isn't the only court case that was challenging RIFs. Where do we stand with the other litigation that's challenging the Trump administration's reductions in force or other sorts of personnel actions?
Yeah, assuming this one goes away entirely, which we think is going to be the case, the main one that's still out there around reductions in force has been kind of floating around the court systems for several months now, and that's the lawsuit, also by federal unions, challenging agencies' reorganization and reduction in force plans. That is still in a little bit of limbo, mainly with the Ninth Circuit Court of Appeals. Just to take you back a minute and refresh everybody's memory, because there have been so many court cases on this, what happened at the highest levels of the judicial system here was that the Supreme Court determined that the president likely had the legal authority to issue an order, basically restructuring the government broadly and ordering reductions in force. But the court explicitly said it was not making any judgments on the individual agency by agency RIF and reorganization plans. So that's where we are right now. What the Ninth Circuit has taken up most recently is whether those individual plans need to be turned over to the union plaintiffs and to the judge to review privately, so that there can start to be some sort of assessment of those plans' legality on a one-by-one basis. That was partly decided by the Ninth Circuit at a 3-judge panel level, and they determined that, yes, those can be made available to the judge. The government has now gone back to the full Ninth Circuit and asked for a rehearing of that decision, so may not even be the final word on that. So basically where we are on that is, after a couple months, we are still arguing over whether federal agencies need to make their reorganization and RIF plans public. So it's hard to even come to any sort of it's hard for anybody, including the judges or the lawyers, to come to a full assessment of whether or not those plans were legal. It is unusual, in my experience, for any federal agency to do large-scale layoffs or reorganizations without sharing any of the details with anyone, but that is where we are with basically all of them. The government is continuing to argue that those plans are shielded by deliberative process privilege and that they are pre-decisional, even though in many cases the RIFs have already occurred.
Well, Jared, since you said that the startup legislation from Congress takes all the reasons off the table and reinstates all of those RIFs, is someone cross-checking to make sure that these older reorganization plans and their RIF strategies aren't reconstructed again?
None of the union lawyers have told me this, but I can almost guarantee you that they are doing that right now to make sure that there's no, significant cross-pollination between those two sort of buckets of cases. But one thing we do know is there was a pretty limited universe of things that could have crossed over. One of them was in the Department of the Interior, who started down the road of issuing some RIF notices that they said had been in the planning stages for many months, but then just kind of stopped that planning process once the litigation started. This gets a little decomplicated by the fact that when you look at an agency by agency by agency perspective, there really weren't that many during the shutdown. There were agencies that did a lot of them, again, the IRS being the biggest, but you really only had a half a dozen agencies that issued RIF notices in the first place. So those are going to be pretty easy to analyze and take apart and see if there was anything untoward happening. But it doesn't look like there are any indications of any kind of mixing between those two buckets as far as we can tell.
That's Federal News Network's Jared Serbu. Jared, thanks for breaking this all down for us.
Thanks, Terry.
You can find his story at federalnewsnetwork.com.